item 23. Yes.
Much.
For admission, item number 25.
Please, Your Lordship, kindly grant us 2 weeks to file our reply to the opposition filed by the government, Lordship.
Matter be listed after 2 weeks at the prayer of the counsel for the petitioner who seeks to file counter affidavit in reply.
Lordship.
What about the state? We have already filed.
Lordship.
State is duly represented. List again after 2 weeks.
Item number 28.
Please, Lordship, I beg to mention on behalf of AIMA. Lordship, if this matter be listed after 2 weeks.
Yes. Prayer for filing affidavit has been renewed by the council for the state council appearing for the respondent, state of Nagaland. Prayer made is not objected to. List the matter after 2 weeks,
Lordship.
enabling the state to file their affidavit. Yes.
Item number 30.
Please, Lordship, on behalf of AIMA, kindly grant 2 weeks time, Lordship.
Why you are adjourning all matters? Is the government not interested? Yes. What do you say?
We don't have objection, Your Lordship.
Right. The matter stands adjourned at the request of the government council, enabling them to file. What you want to file your affidavit?
Yes, affidavit.
Why have you prayed for an adjournment?
To file affidavit, Lordship.
Enabling the government to file an affidavit. Matter stands adjourned at the request of the government council to be listed after 2 weeks. Council for the petitioner does not object to the prayer made. Yes.
I acknowledge.
Item number 31.
Lordship, please, Lordship, the state is yet to file, so kindly grant 3 weeks time, Lordship.
Yes.
No objection.
All right, 3 weeks for filing affidavit at the prayer of the government council. Prayer not objected to by the council to the petitioner. List up to 3 weeks.
For hearing, item number 32.
Please, Lordship, I beg to mention on behalf of AIMA, if this matter will come up after 1 week.
Yes,
Can it be on Monday?
Monday. How many matters on Monday, court master?
Exact numbers, my lord. But fixed
We-
numbers will not be.
Is it available from the what registry?
I've not kept.
You don't keep a calendar.
I'm not the permanent postmaster, code number 1. So earlier it used to be maintained.
So you should maintain. We don't know how many matters are fixed on Monday or what date.
Yes, Lord.
All right, let us keep it on Monday. That's the request of counsel for the petitioner, let the matter be listed on Monday. No objection?
No objection,
All
Lordship.
right, we will keep it on Monday. A joint request, you see. All right,
I acknowledge.
you do one thing, you maintain a calendar. At least in the course list, you make a calendar, then compile and let me know. Right? You talk to him because you need all those dates now. Now you physically maintain it and let me.
For hearing, item number 33.
Please, Lordship, on behalf of Discharge AG in DMSO, kindly grant 2 weeks time. Lordship, if this matter will be listed after 2 weeks, Lordship.
Where is the petitioner counsel? Petitioner. None appears for the petitioner on call. Matter stands adjourned. To be listed after 1 week.
Lordship.
Counsel for MS so and so, rest of counsel appears for the respondent.
Are you pledged?
For hearing item numbers 34 and 35.
May I please, Your Lordship?
Yes.
My lord, WBC 212 may be taken up first.
212. Yes.
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 My lord, the petitioner is Assam Rifle personnel.
Yes.
The allegation of his discharge is incurring 5 rate entries.
Yes.
Through Annexure 1, is the discharge order. What they are trying to see is that without any procedure, just saying that you have incurred so many entries. So you are discharged without following any procedure. That is the whole case, my lord.
Okay.
The rule is very clear that it cannot be.
Now, where is the rule?
My lord,
Where is the
my
rule?
lord,
Is it a part of the pleadings?
para 3 of my writ petition.
Okay. Para 3.
Yes, it
Yes.
was issued 6/4/8, Annexure 6 by such and such. As what? You were enrolled as recruit TD on such and such. Since then, in your service of such and such, you've incurred 4 entries in your dossier. The details of the offenses are given below. First, Army Act, which is not applicable to the Assam Rifles. B also is Army Act. C is Army Act. Only D. What they are saying is that is Assam Rifle Act 26A, absenting himself without leave. So these A, B, and C are none as up in issue for the reason that the Army is not applicable to the Assam Rifles. They have their act. It was 1941. Then subsequently 2006. So why somebody have to be in a establishment where they have their own act and rules?
Yes.
You are saying that he was punished. The record itself is clear that 1, 2, 3
Yes.
under Army Act.
Yes.
So this has to be treated non-est.
Is there any provision under the Assam Rifles Act that certain provisions of Army Act will be implemented or applicable? Direct. Is there any provision under the Assam Rifles Act?
No. To that effect, I've put the actually Armed Forces Tribal name. Yeah, sabi ko. Library will be a
That is the library dedicated to. Are you come?
Malot, I have the copy here. This is Assam Rifle Act 2006,
Okay,
which has repealed it. Section 168, the Assam Rifles Act 1941 is hereby repealed. So the act is very clear. Copy dia. No, sorry.
yes. Yes,
And if your lordship is clear about it, my whole case,
your entire case, you're projecting is that out of the 4 sections,
yes,
3 are under the Army Act.
yes,
So which are under the Assam Rifles Act is not at all.
no. Because they have their own act. Prior to 2006, 1941 was the act.
Right.
So means if we told he's guilty of any it has to be under 41.
Okay. All right.
Then
Now, what about the section under Assam Rifles Act, absenting without leave? What about the section applicable?
Malot,
Yes.
there is only one. See, even if violation, the authority is very clear. It is only D. File 1961. Correct. What? You know.
Yes.
Page 6.
What, page 6 of? Okay, your petition,
My lord.
yes.
The so-called punishment awarded under Army Act Serial A, B, and C are known as an issue for the reason that the Army Act is not applicable to Assam Rifle personnel, but they are subject to Assam Rifles Act 1941 in Assam Rifle Rules 1985. And or that is after 2006, the Assam Rifle Rules
Right.
2010 in regulation of 2016.
Yes,
Then how he was discharged? Annexure 7, page 44. Hmm. 45, my lord.
yes,
Whereas it is considered that the conduct of number sergeant such, which has led him getting for interest, is such as to render his further retention in the public service undesirable, being an incorrigible offender in having shown no improvement during his service. In such and such, was afforded an opportunity to show cause against the proposed action by such and such dated 6 February 2020, in whereas number such and such has submitted his reply by letter 8 May 2020. The same was considered in terms of para 108 of Assam Rifle Regulation 2016 and was found unsatisfactory by the undersigned. Now therefore in exercise of such and such, Record Office Instruction 1 of 2004, Para 5 by Chapter 8, Rule 108 of Assam Rifle Regulation 2016, read with Section 11(1)/2 of Assam Rifles Act 2006, Rule 17 in 25 of Assam Rifle Rule 2010. The undersigned hereby discharges the said number such and such, being incorrigible offender from 31st March 2021. Number such and such is entitled to get pension in service retirement gratuity as admissible under the existing rules. My lord, what Rule 7 says? Rule 7, I've extracted it, page 9 of the petition.
Yes.
Para 6, that Rule 17 of the Assam Rifles Rules 2010 provides the grounds for termination of service as follows. 17, termination of service. Table is given, serial number 1, 2, 3. Then grounds on which service can be terminated. Then the authority is given. Then what are the grounds? Misconduct, unsuitability, unsatisfactory progress in training, furnishing false information at the time of appointment and enrollment, physical unfitness, on own request, not incorrigible. It is not there in the rule. Incorrigible offender is not in the rule. So the ground of discharge itself is which is not in the rule. I can be labeled in any of the Roman bracket Roman 1, 2, 3, 4, 5, 6. So 6.1 I've stated that the respondent authorities discharge of the petitioner from service on the allegation of being an incorrigible offender soldier under Rule 17 in 25 is totally against the rule. As under Rule 17, the word incorrigible offender is totally absent and non-existent. As such, cannot be the ground for discharge. And at the same time,
First, let us do one thing.
yes,
You satisfy us on the supporting materials that the very imposition of the sections under the or punishments under the army rule cannot be done, meaning otherwise
yes,
that the sections or the provisions of the army rule are not applicable to Assam Rifles unit. If you look into their,
my lord, I have a copy,
no, they have filed a counter affidavit
my lord.
where they have stated or referred to some
Yes, sir.
SOs
Yes.
to say that during that particular period of time,
When somebody is attached for training or directly under the army, but the petitioner was never attached to any army.
which notification are they referring to? This is at page
Yang
7.
ako ba kasi? Nangasapat. Assam Rifle, when attached to the army.
Lordship, this Assam Rifle Act is Assam Rifle Act 2006. Prior to that, Army Act was applicable. prior to that. And he was,
No. Assam Rifles Act 2006.
yes,
Prior to that, there was this 41.
Army Act.
No, Assam Rifles Act.
It was under Army Act, Lordship.
No, there was an Assam Rifles Act.
There is an Assam
1941.
Rifle Act 1941.
Which came
Yes,
to be repealed by
yes.
the 2006.
Yes, Lordship.
Now,
Before that, when he was he was under the army.
what is the meaning of attached to army regimental centers?
He was attached with the army prior to 2015.
For your lordship, the respondent affidavit,
Yes,
page 72,
yes.
where it is said that application of the Act of Assam Rifles. So that is what your lordship has pointed out.
Yes,
It is very clear that SRO 117, in exercise of the powers conferred by Section such and such of Army Act 1950, the central government hereby applies all the provisions of the said act to the personnel of the training detachment when they are under training detachment of Assam Rifles, being a force raised and maintained in India under the authority of the central government, during which time period they are remain attached to army.
You're reading from which clause?
Batch 72.
72, the beginning.
Yes,
All right. So what is the,
maintained in India under the such and such during the period. They remain attached to army regimental centers, one. Other army units for training.
okay,
So the petitioner was never attached to it. He was trained in the Assam Rifle Training Center. Never deputed to any of the army unit at any point of time.
correct.
Certainly, when somebody is under the training in the regimental centers of the army, they have to be under a certain regulation, that is army. Itu ini kan strike down. Yes. Then my lord, Rule 17, incorrigible offender, non-existent, then what will happen in case of the Rule 25(1)(b)?
Yes,
What does it require? Enrolled person shall be furnished with the particulars of all matters adverse to him. In Rule 25, clause 2 requires that after considering the explanation, if any, the commandant may call upon the enrolled person to retire or resign. Yes. Just see that my explanation or whatever cause I have shown, if it is not satisfactory, the person can be called upon to retire or resign. That is the rule. This was not done. Only honest refusing to do so, the enrolled person may be compulsorily retired or discharged from service. This was never done. First thing is that Army Act not applicable. Second, show cause without any material.
Yes.
Rule 17, incorrigible offender is not in the provision. Okay, if I'm taken to be guilty as charged, then I have to be called upon to resign. Or to retire, which was
Yes.
not done. My lord, as far as your lordship query about the applicability of the Army Act, this is a Armed Forces Tribunal decision. My lord, it's a short one. I may be allowed to read out.
Yes.
Jurisdiction. Army Act 1950 read as follows, such and such. Army Act 1950 and Assam Rifles Act 1941. That has been considered by the Armed Forces Tribunal. It deals with the armed forces only, not the Assam Rifles.
Yes.
Under challenge in the OA are order dated such and such. The applicant was enrolled in Assam Rifles under provisions of the Assam Rifle Act 1941. He was served with a show cause notice. It appears that the applicant replied the said show cause notice thereafter order dated such and such followed, discharging him from service. A preliminary objection
Yes.
by the Army side has been raised by the Central Government Council that the applicant does not come under Army Act 1950.
Yes.
Here in India, this is, what do you call it? Force Act and Navy Act 1957. Indian Air Force Act 1950, my lord. And Navy Act. As such, the tribunal does not have any jurisdiction to adjudicate upon the controversy raised in the petition. Learned counsel such and such, attention towards annexure such and such show cause, submitted that since the applicant has been charged under the provision of Army Act 1950, the same, this tribunal, Army, have jurisdiction. That is the contention of the petitioner. Section 541 of Army Act 1950 read as follows. 4. Application of Act to certain forces under the central government. The central government may, by notification, apply with or without notification of all or any of the provision of this Act to any force raised and maintained in India under the authority of that government in suspend the operation of any other enactment for the time being applicable to the force. That is, as your lordship has pointed out, SRO 117. The Ministry of Defense by such and such SRO dated such and such reproduced below which Army Act 1950 with a few exceptions has been made applicable to the units of Assam Rifles. When attached and acting, my lord, with any body of regular army. SRO 318 dated such and such in exercise of the powers conferred under such and such Army Act 1950 and in supersession of the notification of the government of India in the late External Affairs Department dated such and such, as subsequently amended, the central government hereby applies to every unit of the Assam Rifles, being a force raised and maintained in India under the authority of the central government, all the provision of the said act, except to specified in Part A of the schedule annexed hereto, subject to the modification set forth in B, Part B of that schedule, when it is clear when attached or acting with the body of the regular army. Suspense while this notification remain in force. The operation of Section 6, 7, and 8 of the Assam Rifle Act 1941. It seems that the applicant was awarded full rate interest delineated in the impugned order under Army Act 1950 when applicant was serving in the Assam Rifle, where provision of Assam Army Act were applicable under the aforesaid SRO, which is not in the case of the present petitioner. The Assam Rifle authorities seem to have taken a note of their full rate increase and issued the show cause notice under the provision of Section 4 of Assam Rifles Act 1941, read with Record Office Instruction 4 of 99 in paragraph 4 of Chapter 8 of Assam Rifles Manual for discharging the applicant from service being undesirable. Undesirable is under the Assam Rifle rules. Since the show cause notice has been issued under the provision of Section such and such of Assam Rifle Act 1941, read with Record Office Instruction 4 of 99 in paragraph 24 of Chapter 8 of Assam Rifle Manual, the discharge has been effected under the Assam Rifle Act 1941. In the present case also, Assam Rifle, in not Army Act 1950. The applicant thus is neither subject to Army Act of 1950, Air Force Act of 1950, nor the Navy Act 1957. As such, this tribunal does not have any jurisdiction to adjudicate upon the dispute raised. The petition accordingly dismissed. The simple question is that no, Army Act not applicable. That is why the Armed Forces Tribunal have no jurisdiction to entertain the original application. Then, my lord, page 10, 6.1. In the present case, no particulars were furnished, as is clear from the show cause notice, nor was the petitioner called upon to retire or resign. But straight away, he was discharged in total violation of the rules. No inquiry as given in rule was held against the petitioner, which is against the statutory rule and against the natural justice of the citizen. As such, this ground itself is sufficient to quash and set aside the impugn show cause. I am challenging even the show cause in discharge order. Then overstay, absence without leave, or drunk. These are minor punishment. 6.2, that the punishment awarded to the petitioner is shown to be 14 days RI in Assam Rifle custody, not in the army custody. In below, hence the punishment comes under section 62. What section 62 says, my lord? Subject to the provisions of section 63, which is for the officer, a commandant or such other officer as is, with the consent of the central government, specified by Director General may, in the prescribed manner, proceed against a person subject to this act. Otherwise, then an officer or a subordinate officer or warrant officer who is charged with an offense under this act and award such person to the extent prescribed one or more of the following punishment, that is to say, this is minor punishment. Imprisonment in forced custody up to 28 days, that is the maximum. Then 6.3, the Assam Rifle Act of 2006 under section 97. What does it prohibit? Double jeopardy.
Assam Rifles Act,
Yes, 2006,
page, section
97.
97.
Yes, this is
Yes.
prohibition of second trial. One, when any person subject to this act has been acquitted, or in my case, convicted. I am convicted. Take it.
No, you have to give us a bit of the history of what led to these proceedings.
My lord.
What happened?
My lord. Earlier, you was discharged.
Why?
On the same question, but in that proceeding, it was the commandant who discharged him.
The four readings.
Yes, it was 5 that time.
Five readings.
Yes. Then
He was discharged without any proceeding.
same, yes. But it was not the question. The question was whether the commandant had the authority to discharge. Till 1941 Act, commandant was the full authority. By 2006, it has been taken away. Commandant cannot discharge. On that ground, the petition was allowed by this honorable court. Then, after reinstatement, again, he was given this show cause notice by the competent authority. Let's call it DIG. On the same ground.
The same ground.
Yes.
With regard to the same
Yes.
allegations.
Yes. Then on that basis, again, without any proceeding, he was discharged.
No, in the earlier proceedings,
Yes.
was there any finding with regard to?
No. Army or Assam Rifle, that was not the issue. The issue was whether the commandant.
Was competent.
Yes. So that was the
No,
issue.
no appeal against that order.
No,
appeal.
no. So now they have taken this, the same ground by the competent authority. That is the DIG. So I'm not questioning about that particular issue. But the question is, whether Army Act is applicable to the Assam Rifle or not.
There is a judgment of the High Court
My lord,
saying that it is applicable,
my lord,
that both Army and Assam Rifles Act are applicable.
my lord, what I'm trying to bring it to your lordship is that the Armed Forces Tribunal has said that no, Assam Rifles.
Armed Forces Tribunal, this order which you have placed before us
My lord,
is essentially on the point of jurisdiction.
my lord,
There
Yes.
is- There is no in-depth finding that by proper decision as to whether in terms of the central government modifications, whether the Army Act can be applicable.
yes,
It is only question of whether Assam Rifles personnel are amenable to Armed Forces Tribunal or not. That's the only.
my
issue.
lord, the SRO is very clear. Yes, when they are attached, they are applicable.
No, but the judgment of the High Court goes a little beyond. Have you?
That
I-
one, I'm not aware of that, but one thing is that the SRO is very clear.
No, there's a judgment here.
72, page 72 of the authority responded.
Was the unit under the operational control?
No,
Not at that time.
no. He was never attached.
No, not he, the
Yes.
unit,
No,
his unit to which he belonged. Was it under operational
no.
control? Okay. Yes.
So their own document is very clear that remain attached to army
Hmm.
or under training.
What does Rule 25 prescribe?
Rule 25. You read. Rule 25 is termination of service of enrolled person on grounds of unsuitability, not other. One, where a commandant is satisfied that an enrolled person is unsuitable to be retained in the service, the enrolled person shall be so informed.
Okay.
So take it as
Not applicable in your case.
no. Show cause was given to me,
Ah.
so it is informed,
All right.
but without any other documents. B says furnished with the particulars of all matters adverse to him. Not furnished,
That was not for.
no. They came up in the affidavit in opposition.
With the documents.
Yes. So it is clear that the whole proceeding was under section 62. That is minor punishment. Here, that is your own documents.
Yes.
Call upon to urge any reason he may wish to put forward in favor of his retention in the service. Provided that clause A, B, and C shall not apply if the commandant is satisfied that for reason to be recorded in writing, it is not expedient or reasonably practicable to comply with the provision thereof. In my case, that is not the issue. Provided further that the commandant may not furnish to the enrolled person in what cases any matter adverse to him, if in his opinion, it is not in the interest of the security of the state. If I am absent without leave or it will not jeopardize the security of the state. Sub rule 2, after considering the explanation, if any, the commandant may call upon the enrolled person to retire or resign. And unless refusing to do so, then the enrolled person may be compulsorily retired to discharge from the service. Itu itu TV
I have
Malo.
got a copy. You're referring to rule
Yes.
25.
Yes.
25.
Yes,
I have it.
Malo. So they came up with the proceedings in the affidavit in opposition, not at the time of show cause. What is given is it starts from page 25 of the affidavit in opposition.
Yes.
What this has done is that they have set aside the Army Act proceeding. Such and such. I set aside the summary trial proceeding in respect of number such and such held on 2009 on ground of lack of jurisdiction. They admitted as the proceeding were conducted under Army Act 1950, Section 39B, for without sufficient cause, OSL, overstaying leave granted to him. There was no proceeding on 29 June 2009. Then again, same, page 26. I set aside the summary trial proceeding in respect of such and such, held on 8 April 2010 on the ground lack of jurisdiction, as the proceedings were conducted under Army Act 1950.
Yes.
Proceedings. So the moment they themselves have set aside some of the action they've done under Army, it goes without saying that the whole Army proceeding are
These are in your respect of proceedings against you or some?
yes, my lord. The name is clearly given.
Okay. Now, pursuant to this, further proceedings were drawn up again. After setting aside,
No, no,
nothing,
no.
then how are you discharged? Who discharged you? The DIG?
DIG.
And these orders are passed by whom? The commandant? Page number 25.
Brigadier. So we have the authority. He have the authority. I'm not questioning about his authority.
Okay.
Competent authority have set aside.
Where is that, where is the order of discharge?
Page 44. Yes. 45, my lord. Brigadier authority.
This is 22nd of March.
Yes. Being incorrigible offender with effect from 31st March 2021. Incorrigible offender is not there in the rule.
And according to you, this is not defined. Incorrigible offender.
No, it's
Not
not the rule 17. Rule 17, I've reproduced in my writ petition itself, page 9, para 6. Rule 17.
Yes. Show us this provision where 5 or 4 red marks entitled discharge, invites discharge.
And we are projecting it to be under record office instructions in Regulation 108. Regulation 108. It starts from Regulation 107.
Okay.
07, that is removal of undesirable incorrigible register in inefficient subordinate officer under officer in other enrolled persons. But the condition is laid down clearly. a subordinate officer, under officer in other enrolled person who by his conduct has proved himself undesirable, incorrigible, inefficient, in whose retention in the service is therefore considered unsuitable. For the force will be recommended for discharge and dismissal from service. Dismissal should only be recommended when Assam Rifle Corps, if held, would have awarded the sentence not less than dismissal, but trial by Assam Rifle Court is considered impracticable or inexpedient. In other cases, recommendation will be for discharge from service. Then B, before recommending or sanctioning discharge, the following points must be considered. Small Roman 1, if lack of training is the cause of inefficiency, arrangement will be made for his further training. Small Roman 2, if an individual has become unsuitable through no fault of his, he will be recommended for suitable extra-regimental employment instead of discharge from service. Then C, the procedure for dismissal in discharge of unsuitable subordinate officer, under officer, enrolled person will be as under. Small Roman 1 as provided under Rule 24 in 25, which your lordship has gone through. The person concerned, subject to the exception mentioned therein, shall be served with the show cause notice against the contemplated action. Then Roman 2 is there should be a preliminary inquiry. Preliminary inquiry before recommending discharge or dismissal of an individual. The authority concerned will ensure that an impartial inquiry, not necessarily a court of inquiry, has been made into the allegation against him in that he has had adequate opportunity of hearing. In the present case, no inquiry, no opportunity of hearing. Roman 3, Rule 24 of the Assam Rifle confers power on the commandants of the unit in establishment to discharge any subordinate officer, enrolled person of Assam Rifles. However, my lord, the power of discharge by commandant shall be exercised with the prior approval of immediate superior officer not below sector commander. In the case of such and such, an enrolled person, I'm as enrolled person, supplied. And that of Inspector General in case of subordinate officer, which is not. So as per the regulation, it is the commandant.
Yes.
After compliance of the provision enumerated above, then show cause notice will be served on the individual, affording him an opportunity to explain his case. Thereafter, the complete case file will be forwarded to the next superior authority sector headquarters for approval of the superior authority sector commander. Then, small Roman 5, the authority competent to sanction the dismissal or discharge of the individual will, before passing order, reconsider the case in the light of the individual reply to the show cause notice. A person who has been served a show cause notice for proposed dismissal may be ordered to be discharged if it is considered that discharge would meet the end of justice. If the competent authority accepts the reply of the individual to the show cause notice as entirely unsatisfactory, he will pass order accordingly.
Where is that
Then-
order? Where is that order? Where is that order passed by the competent authority?
No,
No order,
no,
not served upon you, even if passed.
no. Then what they are relying is regulation 10E. Discharge on ground of red ink entries, my lord.
Yes,
Such and such enrolled person, a subordinate officer, under officer, or other enrolled person who has incurred 4 rate or more rate entries may be recommended for discharge from the service on the ground of unsuitability. But the conditions are laid down clearly. A, after an individual has earned 3 rate entries, he shall be warned in writing that his service will be liable to be terminated by the competent authority if he earns 1 more rate entry. Such a warning letter shall be issued to him by the concerned sector commander through commandant of the individual. Shook was by the DIG, so that is the competent authority. B, each case of individuals having earned 4 or more rate entries shall be examined on its own merit, depending upon the nature and gravity of the offenses, in the aggravating circumstances under which these were committed. The authority competent to sanction discharge under this para shall record reasons. Reasons should be given for ordering the discharge or otherwise. C, a person who is both in 18 years of qualifying service for pension may be allowed to complete the required qualifying service or grant of pension before he is recommended for discharge on the ground of 4 or more rate entries, unless there are compelling reason to sanction his discharge before completion of the qualifying service for pension, which must be specified in the discharge order. D, before taking the final decision to order the discharge, the person concerned shall be informed through a show cause notice. I was informed that his retention in the service is considered undesirable for having incurred 4 or more rate entries, thereby also calling upon him to show cause as to why he should not be discharged from the service for being considered unsuitable.
you were informed by show cause notice.
Yes. The service in the Assam level, the individual shall be given minimum 15 days after receipt of the show cause notice to submit his reply. So it was COVID time. So the petitioner submitted the through WhatsApp, which my learned friend annexed. My learned friend annexed page 44 is the reply given by the petitioner.
Page 44.
Yes, but it is not an admission. I may be allowed to read out, my lord. From Mr. Such and such petitioner to Commander, then Sector Assam Rifles,
Page number?
44 of the affidavit in opposition.
Next to that, okay. Page number 4,
44,
44.
yes. Type copy also the furnished 44A,
44 of the affidavit in opposition.
my lord.
Okay.
Sir, I honored to state that during my 19 years service, had got 4 charge sheets. Therefore, may I kindly request you to apologize for my mistaken in late continue of my service for further that I will not going to repeat any mistake again. That is 8 May 2020, and it was during COVID time.
This was sent by WhatsApp.
Malo.
Yes.
Then Regulation 108E, after receipt of the individual's reply, if any, the case shall be put up to the authority competent to sanction the discharge along with recommendation of the commandant of the unit concerned. Before passing the discharge order, the authority competent to sanction the discharge under this para may seek the advice of law officer concerned. No. The order doesn't show that.
This red ink is to be put where in is there an ACR or service record? Is
My
red
lord,
ink-
I'm not sure. But one thing is that
where is it put in the
Oh,
service record?
in the army term, they call it service dossier.
Service
dossier.
dossier.
Yes. There is a record on
Who puts it?
the command.
The commandant. Is it brought to the notice of the personnel?
Yes,
That
it is.
certain such.
I will satisfy you that much.
my lord, when somebody violates a certain rule, that is, they have 1, 2, 3 core. That is general, petty, and summary. Summary is fully the commandant. So he can punish it, which comes under minor punishment, that is section 62. So he is the whole authority. Petty will be 3 officers, general will be 5. So depending on the
Gravity of the offense.
Malo. So
Now, this proceedings were held by whom?
by the commandant,
Commandant.
yes. So he is after receipt of the individual's reply, it is before passing discharge order, the authority competent to sanction the discharge under this para may seek advice of the law officer concerned.
Yes.
If is sector commander, which I'm not questioning, in the case of such and such, and an officer not less than IGB, IGAR, additional AGR.
Yes.
So I'm not questioning about that.
Yes, please.
So it is summary proceeding. Then page 12 of my petition. para 6.3 that Assam Rifle Act 2006 under section 97 prohibits as follows: 697 prohibition of second trial. When any person subject to this act has been acquitted or convicted, it can be either way. In my case, take it, I am convicted of an offense by the Assam Rifles Corps or by criminal court, or has been dealt with under section 62 or 64 or 65. Enrolled person comes under 62. He shall not be liable to be tried again for the same offense by the Assam Rifles Corps or deal with under the said sections. This is double jeopardy. That is the safeguard given.
Why is it double jeopardy? Why?
My lord, when somebody is acquitted or convicted,
No,
Yeah.
so the earlier orders passed by the commandant,
my lord,
uh, in respect of those offences, a further, trial was conducted, proceeding was conducted?
no.
No. Then how is it double jeopardy?
My lord, what I'm trying to say, if somebody is acquitted or convicted,
But it must be relating to the same charges.
so he cannot be punished. Because already punished,
No, for the same
Yes.
charges.
yes,
Charges must be same.
my lord.
Are you saying that for the red, uh, what do you call red marks? He was earlier acquitted.
No, no. Punish,
So the commandant only dismissed those 3 charges pertaining to Army Act, which you pointed out.
my lord.
You pointed out certain orders passed by the commandant.
Yes,
Those are pertaining to
Army Act,
charges under the Army Act.
my lord.
Now,
By the commandant of the Assam Rifle.
Assam Rifles, correct. But where is that discharge order again?
44. 45 is the
45.
order.
Where is that show cause notice?
Page 40. May I read?
Yes.
Show cause notice, 6 February 2020. One, you were enrolled as recruit general duty on 19 November 2000 in Assam Rifles. Since then, in your service of 19 years, 2 months, in 17 days, you have incurred 4 rating entries in your service dossier. The details of the offenses are given below. Serial number A.
One minute. And where are the orders passed by the commandant regarding these offences under the Army Act? You had pointed out, setting aside 25, na?
Yes,
Page number 25.
page 25 of the Assam, the opposition.
Right. So according to you, these charges, these offences or these allegations were already interfered or set aside by the commandant earlier,
Brigadier,
by the
brigadier.
brigadier.
Yes.
So who's the brigadier? What is the role of a brigadier? Is he in the rank of a commandant or higher officer? Is the higher officer?
Brigadier. Higher than the commandant. So serial A is Army Act, Section 39A. Absenting himself without leave.
Okay.
3rd December, date of offense, 2006, statement of offense in that he at field absented himself without leave from unit lines on 3rd December 2006 at 16:30 hours to 4th December 2006 at 6:30 hours. Total period of absence 14 hours. Punishment awarded. Awarded 14 days RI in Assam Rifle custody on 9 December 2006 by Colonel K.B. Sherudhi, Commandant 42 ER. So it is clear that the punishment was by the Assam Rifle Commandant.
So what does it signify?
My lord, of the army, it should be by that authority. Army Act, Section 48, intoxication, 20th November 2008. In that such and such on 20 November 2008, it about 2015 hours was found intoxicated while reporting back from outpost. It company, I don't know, LOC, IOC or LOC, page 40. Contrary to Patlin's standing order, awarded 3 days RI in Assam Rifle custody on 21st November 2008 by Colonel KBS Serohi, Commandant 42 Assam Rifle. C is Army Act Section 39B without sufficient cause overstaying leave granted to him 29 December 2008. On 27 November 2008, having been granted 30 days early plus 2 days, I don't know, GB with effect from 27 November 2008 to 28 December 2008, feel without sufficient cause to rejoin duty on 29 December 2008 forenoon and expiry of the said leave, till he voluntarily rejoined on such and such. Total period of absence 45 days. Awarded 3 days RI in Assam Rifle custody on 13 February 2009 by Colonel Sergeant Such, Commander. Then D. This is Assam Rifle Act now. Assam Rifle Act Section 26A, absenting himself without leave. That is, date of offense 22nd February 2019. In that he at field on 22nd February 2019 absented himself without leave from transit game Minotong from 22nd February 2019 forenoon to 15 March 2019 afternoon. Total period of absence 22 days. Awarded 7 days RI in forced custody on 6 October 2019 by Colonel Huyan, Commandant 42 ER. Baratu, after you have incurred 3 ink entries, a warning was given to you by such and such, dated 14 February 2009. To show improvement, it is clear from the above that in spite of having been advised many times to improve your conduct, you did not show any improvement. You were already warned that if you incurred 4 ink entry, your service would be terminated. Now you have incurred 4 ink entry in your service dossier. 3, you have thus become an incorrigible offender. Keeping in view, it becomes essential to initiate action against you, that is, discharge from service, under Section 11(2) of Assam Rifles Act 2006 and Rule 25 of Assam Rifles Rule 2010. You should submit your reply to the show cause notice within 30 days of its receipt, failing which it shall be presumed that you have no grounds to argue against the proposed action, and an ex parte decision will be taken against you. So
Where is the act, where under the act or the rules is the procedure laid down as to how these proceedings are to be conducted? This is a show cause. You
Malo,
have been asked to reply by virtue of the show cause.
yes,
So you have replied. Where is the provision as to how your reply will be dealt with by the authority? Is it under the act or the rules?
Milano.
Lordship, all these proceedings
Hmm.
were recorded, in the,
Affi-
if my lordship, like,
Yes,
page 39,
Of,
my affidavit,
okay,
this is page 39, annex 6.
59. Yes,
Form of
Right.
hearing of judge.
no, this is the record,
Yes, Lordship.
but where under the act or the rules are the procedure laid down?
This is under the Assam Rifle Act.
Rule 41, no,
Rule 25.
Rule 25 of the,
Rule 25,
of
only
the
Rule 25.
page 175, 173. Yeah, it's awesome. Yeah, Lord. 25, termination of service of enrolled person on ground of unsuitability.
Rule 25,
Yes.
yes,
Termination of service of enrolled persons on ground of unsuitability. 1, where a combatant is satisfied that an enrolled person is unsuitable to be retained in the service, the enrolled person shall be A, so informed. B, furnished with the particulars of all matters adverse to him. And C, call upon to urge any reasons he may wish to put forward in favor of this retention in the service.
how is this satisfaction required to be arrived at by the commandant? How does he arrive at this satisfaction?
Lordship, if my lordship may see the page, starting from page 39. Page 39, yes.
Yes.
Is in the form, on the last right-hand side, whether accused cross-examined the witnesses or declined to cross-examine, only state yes or decline
No,
before
this
each
is,
witness as applicable. Decline, he has declined.
this is after you issue a show cause.
Yes,
You look into Rule 25. It
Yes.
begins with the word that where the commandant is satisfied.
yes.
He arrives this satisfaction on what basis? Is there any procedure laid down?
Worship-
Yes.
The watchman just have page 4 of the writ petition. The order itself which we pass shows the procedure which we follow.
Page,
Page 45 of the writ petition, which is the order we passed.
Come.
What your lordship was pointing out at Rule 25, we issue him a show cause notice. So when he incurs 3 reading entries.
no.
Please.
This show cause notice is to be preceded by a satisfaction of the commandant. You look into Rule 25,
Yes, your lordship.
where the commandant is satisfied.
Your lordship, just see page 40, what the procedure is. So he has 3 punishments which for different offences awarded to him. So once 3 punishment he gets, we issue him a warning letter that if you get a 4th reading entry, we will take administrative action against you, which may be for your discharge on basis of these 4 reading entries.
All right.
So when
This-
this is
this-
issued to him,
This is on the basis of the regulations, 107 and
Yeah.
8.
yes, your lordships. Then when this warning letter is issued to him, if he incurs a 4th reading entry, on basis of that punishment, then we give him a show cause notice that now because you have not improved yourself and you've got 4 reading entries, now you show cause why administrative action should not be taken against you. Then the reply, once he gives a reply, whatever reply he wants to give, sometimes they ask for another opportunity.
This ink entries, red ink entries that you put in the record,
Please, your lordship.
is it brought to the notice of the?
Yes, in your lordship, just see page 40. Page 40, all the details with the offense and everything is put to his notice. His receipt is also taken.
No, this is, see, this is after you put the red ink entries.
Yes, your lordship.
So once you put a first red ink entry, is
Yes,
it brought to the notice of the person?
Yes, your lordship. Because
By what? By which
once
process?
your lordship offense happens, I'll show it from our counter affidavit itself, what the learned counsel was pointing out, that he is sent to the commanding officer. The charge is read to him. He's told that this is the offense. Do you plead guilty, not guilty? Then if he pleads guilty, then the punishment is afforded, which is the reading entry. Say rigorous imprisonment of 4 days, 5 days, which in his case can be shown at page 40.
All right.
Then it is entered in his record. Once it is awarded, then it is entered, then it is sent for legal vetting also.
So you are saying that before the red ink entries are put in the
Record.
record,
Yes, sir.
there is a question, there is a requirement of show cause on the
It
person.
is like a trial, your lordship, a small trial where he's marched up to the commanding officer who sits as deciding whatever evidence against him is there produced. He's asked, you plead guilty. So
Do
if
you have a name for this trial, for a court?
it's a summary trial, your
It's
lordship.
a summary.
It's
trial.
a summary trial. And these 4 summary trials amount to 4 reading entries. There are 4 different punishments for different
And
offenses.
under what provision do you have, can you convene a summary trial? What-
That provision.
What are the provisions here?
Section 62, your lordship, of the Act of Sam Rifle Act.
Two.
Please, your lordship. These are certain minor punishment which only a commandant can award. For any punishment which is more severe like dismissal, discharge from service, it is the higher authority which is a higher rank who can do it.
Okay. Yes, Mr. Council, we'll come back at 2.
Malo,
We'll continue at 2.
malo.
Yes.
The petition didn't show up, nah? That's the case, right? There's no one for the petitioner. Yes. Channel on behalf of new teams. Yes. No, it's a full name then. No, it's okay. Right. One hour. Something. Can you please ask from the other channels? Some bichano. Bichano, BICHA, no bichano, something one surname. Sure. Isn't that
The second half of the case that reverse also. So.
这是啊，这叫老母不干嘛？老母都往他身上走。
我最是比如说他还为了啥的嘛，给到我这有他后面给到什么？
他就管。
他还为了啥的嘛，给嘛死的有他后面给到我。
多回来就是的。啊，不是那么吃，
This I think better to the.
不是那么吃那个嘛？
Second one,
哎，你们才有。
preparation that. That's not. 那个来的菜了，菜。
你看这儿，我也不这个。
一个，哎呀，菜吧，那是不是我呀的菜吧？可是那 energy 啊，这个菜。
还在。
一个那个大菜个，啥都是不那么个菜的。哦，这个那菜的菜嘛，不那么。可是，来选的是把它来。
就 clear 把它老。layers 老老。
啥那个不是菜。
이거 예마sob자
Making of ground not more.
really yeah.
Kariba. Tabangan lewa. Ah. Ne chukuch ko yo. Mention sa chukuch ko. Mention sa chukuch ko yo. Ko mention. I think 37 to mention could be. Okay, when I like it.
영어로 듣는 이유가
Right now.
Whole hearing will need to. Yes. Adjustment. Yes, that's the way. I love that. Sorry. Another one there? No. Yung ano tradisyonel ya, orang mau wes. Saya lem bulan. Itu tradisyonel lah, sekitar, sekitar, ya player main. Kan bisa kita hampir macam. Ada mesti mau lihat supaya jadi macam. Dua salah satu tradisyonel, saya juga macam nampak dari. Dan misalnya saya May I have your lordship's attention to item 37?
37, yes.
37. On earlier occasion, this matter was fixed today,
Yes.
but then in view of the other measures which has been taken up, it's not likely to finish it early, lordships. So it's a consensus prayer on behalf of all the councils that this matter may be taken up on Tuesday, that is 12th.
12th.
This week I have some difficulties.
How many matters on 12th?
I think very few matters are fixed. Monday, we have few cases fixed.
You have already done your homework.
Two hearing matters. Two hearing matters also.
All right, Tuesday,
As a fixed item, lordship.
Tuesday. Item number 37.
Yes, lordship,
37.
in the hearing list.
As agreed to, the matter be listed on Tuesday, which is on 12th.
May I place your lordship?
Interim may be continued in that.
Interim order.
Yes.
Interim order, if any, will continue until further orders.
Lordship, I also like to beg to mention item number 39. Lordship may kindly list this matter after 2 weeks. I have taken the consent of the petitioner.
All right, if it reaches, we'll do, otherwise it will be left over. It'll come anyway after 1 week or 2 weeks. You want it after 2 weeks?
Lordship,
Item 39 after 2 weeks. Consent of the council for petitioner has also been obtained.
Lordship, similar prayer with item number 40.
39 and 40.
Lordship,
Okay, 39, 40. All right,
I oblige, Lordship.
yes. We'll complete your arguments today if you want. And then we'll hear you on, we can continue today or on Thursday also.
Depends on the lordship.
No, depends on how long Mr.
Yes.
MD is going to address the court. So essentially, your argument, your submissions are particularly on this, that number
19
one, these are all, 3 of the allegations are under the Army Act.
Yes, when 1941, Act of Parliament is still ruling the Assam Rifles.
So Assam Rifles has no jurisdiction to invoke powers under the Army Act.
No, since they have their own act,
That's right. So there's no question of invoking
yes,
powers
yes,
under Army Act.
neither Navy or Air Force or Army.
The second is that these 3 of the or 4 of the allegations were already set aside by a competent authority
My lord,
earlier.
yes, they themselves have declared that Army Act is without jurisdiction.
And the procedure prescribed under this Rule 25, as well as Regulation 107 and 8 has not. been
Yes, not followed.
Not followed. Right. Yes.
Then, when he was discharged earlier by authority which is not competent, page 8,
Page,
page 8 of the writ petition.
page 8.
8. Paragraph 5.1. That is when on 15 May 2010, the petitioner shown to have 5 red ink entries. Then how come in 2020, it got reduced to 4 red ink entries in the petitioner to Zian? This action shows the respondent authority is acting like Henry VIII, which is given in 1986 EIR 1571 in Central Inland Water Transport Corporation versus Procedural.
Rajanath Ganguly.
Yes.
Yes.
So a naked hire and fire rule, the time for punishing which altogether from employer and employee relationship is fast approaching. Its only parallel is to be found in the Henry VIII clause so familiar to administrative lawyers. As all lawyers may not be familiar with the administrative law, we may as well explain that Henry VIII clause is a provision occasionally found in legislation conferring delegated legislative power, giving the delegated the power to amend the delegating act in order to bring an act into full operation or otherwise by order to remove any difficulty in it times, giving power to modify the provision of other acts also. See, other acts also. The Committee on Ministers' Power in its report submitted 1932 pointed out that such a provision had been nicknamed the Henry VIII Clause because that king is regarded popularly as impersonation of executive authority. So this is a classic example, case of the respondent authority autocratic abuse of the act, rule, the regulation, at your whims and fancies.
Yes.
To the show cause as well as the impugned discharge order is liable to be dismissed, quashed. As your lordship has noted, 2006 rule act has repealed only 1941, not the army, nor the navy or air force. Meaning thereby 1941 was in force till 2006. That is the whole meaning. Then para 11. That the petitioner has been discharged from service by the respondent authority without conducting any inquiry or trial, as mandated by rule in the most capricious and whimsical manner, in gross violation of the provision of law and Article 311(2) of the Constitution of India, which I've reflected. Then I've includes one ruling, para 13, that in the case of Union of India, in Others versus Molindra Choudhury, High Court of Gauhati, 1998, 4G LD 68, writ appeal number 127 of 1995, decided on 20th/11/1995. This is by the Chief Justice. Para 9, it is a declared concept of law that once a citizen has been offered a post, and the citizen is working by virtue of an order of appointment, the provision of Article 311 of the Constitution come to its rescue. Such being the case, it is not possible to take a different view from the view expressed by the learned single judge. If at all the appellants wanted to take action to terminate the service of the writ petitioner respondent, they would have followed the procedure known to law. This having not been done in this case, we are of the view that the conclusion reached by the single judge was perfectly correct, which does not call for interference. Molindra Chaudhary case,
You're referring to which paragraph?
paragraph 13 after writ petition.
1, 3.
Yes.
Okay.
So I've annexed it, page 46. This is a CRPF personnel.
1 minute.
Annexure 8.
Just 1 minute. Yes.
May I read out?
Page number
46.
6. Yes, yes.
Termination, service law, termination of service by oral order. Order of recruiting officer indicating that the petitioner was selected in offered appointment. Play that as there was no written order of appointment, there need not be any written order of termination. Rejected. Constitution of India, Article 311, termination of service by verbal order. Legality of verbal order termination held antithetical to Article 311. Sri Malindra Chaudhary, the respondent herein, was the petitioner in civil law such and such, challenging the correctness in legality of the verbal order of appellant number 2, seeking to terminate the services of the writ petitioner as Constable Taylor, that is TLR, the learned single judge by order met on 25th April 94 after hearing a learned counsel. After hearing learned counsel on both sides, allowed the writ petition with the writ of mandamus, directing the appellant to allow the petitioner to continue in service. Aggrieved by this order, the appellant have preferred this appeal. We've heard Mr. Such and such, learned counsel, as well as Mr. Such and such. Mr. Such and such, learned standing counsel for the Union of India, has taken us through the order of the learned single judge under appeal, the grounds taken in the appeal, as well as other documentary evidence. He argued that there was no order of appointment in writing. The question of any right arising in favor of the writ petition that could be considered by the court did not arise at all. However, the learned single judge, not agreeing with the stand taken by the Union of India, recorded the findings which were contrary to the stand taken by the Union of India. Therefore, according to him, the conclusion reached by the single judge is not correct. It was pointed out that at the physical fitness examination, it was found that the measurement of the chest of the writ petitioner was deficient in that he was not selected. This aspect of the matter has not been properly considered by the learned single judge. Lastly, contended that as there was no order of termination in writing, the question of challenging such order did not arise. Learned single judge ought to have seen this specific stand taken by the Union of India while arriving at the conclusion in favor of the writ petitioner. Mr. Such and such, learned counsel appearing for the respondent writ petitioner wants us to sustain the order of the single judge, saying that the same is justified. Para 5, in order to proceed the legal contention urged for the appellant, we have perused Annexure 3 to the writ petition. It appears there from that the commandant arose by an order made on 21st June 91 issued the following order. not the formal appointment order. You are hereby directed to report along with the following documents to the Commandant 128 Battalion CRPF BO Americo Kanabara Gauhati 23 and such and such. 1. A. All educational certificate in original. B. An original certificate in support of your date of birth. C. Scheduled caste and scheduled tribe certificate. D. Pre-verification certificate duly signed by a gazetted officer in countersigned by the DM, district magistrate or subdivisional magistrate or either superior officer, blank form includes. E. Miss advance appropriation such in personal expenses as per your requirement. F. Light bedding in personal clothes includes Mr. Recruiting officer. By perusal of the nature of the order passed by the condition incorporated in the order, it is undoubtedly clear that the commandant, having selected the writ petitioner respondent, issued an order of appointment to him as Constable Taylor in CRPF. Looking at the condition in the order, it cannot be construed to be only a direction directing the petitioner to report before the commandant. As contended by the learned counsel for the appellant, in other words, the stand taken by the Union of India is that this Annexure 3 should not be construed to be an order of appointment. On the other hand, looking at the circumstances under which this order has been issued after selection of the respondent, the commandant having issued the order on 21st June 91, learned single judge held that it was an order of appointment calling upon the writ petitioner to report for duty on 26 such and such. This conclusion of the learned single judge does not call for interference. In other words, that order deserves to be held correct. That is their own order. 7. Considering the chest measurement of the writ petition as referred in the counter affidavit presented on behalf of the appellant here in filing writ petition, it was found that the chest measurement of the writ petitioner was found to be 75 cm unexpanded in 80 cm expanded. According to the Union of India's disclosed in the counter affidavit, this measurement does not fulfill the prescribed standard. He was found to be overaged, and therefore he was not eligible for appointment to the post of constable in CRPF. And as such, he was asked to leave headquarters of the CRPF. Learned single judge, considering the facts and the circumstances in the stand taken in the counter affidavit, observed as follows. The case of the opposite party is that no letter of appointment was issued to the petitioner, but Annexure 3 will show that the question of medical examination of the petitioner at this stage does not arise in as much as he was asked to report with the documents mentioned therein. He was medically examined earlier, and the question of his chest measurement at that stage does not arise. Learned single judge further observed as follows. Be that as it may, it appears that the service of the petitioner was terminated in the most arbitrary, capricious, and whimsical manner. A person cannot be thrown out from service according to pleasure of the authority. It must be done for some reason, and this reason must be communicated, made known to a person as the authority is taking away the livelihood of the petitioner, and that was not done in the instant case. These observations are made by the learned single judge basing upon certain facts. Considering this observation, at the outset, we were not satisfied with the stand taken by the appellants that the petitioner respondent was not appointed as stated above. It is clear from Annexure 3 to the petition that it was an order of appointment, and in response to the said appointment, the petitioner reported for duty. So extracted portion is 9. It is a declared concept of law that once a citizen has been offered a post, the citizen is working by virtue of an order of appointment. The provisions of Article 311 of the Constitution come to its rescue. Such being the case, it is not possible to take a different view from the view expressed by the learned single judge. If it all the appellants wanted to take action to terminate the services of the petitioner respondent, they could have followed the procedure known to law. This having not been done in the instant case, we are of the view that the conclusion reached by the learned single judge was perfectly correct and does not call for interference. So if you want to take any action against me, you should be given the opportunity of being heard. Take it that show cause, yes. I've not directly admitted, but I apologize. We need this apology. It is to be taken that you have not admitted the allegation. Then there should be a proceeding followed by witnesses.
Yes.
Then para 15, para 14,
Of
my petition, yes. He was illegally discharged without following due procedure of law and rules in the so-called alleged forward entries incurred by the petitioner during his service does not make his discharge mandatory in the action of the respondent authority discharging petitioner from service without holding an inquiry, which is not permissible in the eye of law. And it is against the statutory rule, as your lordship has clearly pointed out, regulation 108.7 in it. That is clear. Then that the petitioner's discharge order passed without application of mind by respondent authority as the respondent being punished under the Army Act and the respondent authority discharging the petitioner from service under Assam Rifle Act rules or regulation, which is illegal, as one cannot be punished under different provision of law. That is Assam Rifle Act rules and regulations. So my humble prayer is to question it, decide put show cause, because that is not as per the rule in as well as the discharge order. I may be allowed to place your lordship two citations at the Shillong bench.
yes.
30, yes. First, so yeah, that's. One is this is a single bench.
Yes.
Rupees Shreya Vanshi, my lord. Since it is short, I may be allowed to read out with the rulings.
You're referring to the single bench first.
But
Okay. Uh, Yes.
so the brief fact of the case in nutshell is that the petitioner Rupees Suryavanshi joined Assam Rifle as general duty in the year 2006. During his 4 years and 6 months of service, he has been given 4 red egg entries under the Army Act of 1950. And he was finally discharged from service by Commandant 4th Battalion A Assam Rifles, White Border Sergeant Sarge, 1910, that being agreed by the said impugn order, the petitioner approached this court by way of instant writ petition. Heard Mr. Sergeant Sarge, learned counsel for the petitioner submitted that first red ink entry was made on 4/11 of 09 on the ground that he has been absent from without duty, without leave for about 10 hours, 10 minutes, and he was awarded 14 days arrest. And charges were framed in the same day. The second writ entry was made on 9/3 of 2010 on the ground that he was found intoxicated during the camp barrett and was awarded 21 days RI, and charges were also framed. The third writ ink entry was made on 8/6/10 on the ground that he was found intoxicated and 28 days RI was awarded and charges were framed. The fourth writ entry was made on the ground that he was absent from duty without leave for a period of 14 days and awarded 28 days RI, and charges were framed. The learned counsel for the petitioner contended that though punishment has been awarded against the delinquent official, but the same has not been followed by any procedures in rules, no inquiry has been conducted by the authority before taking action, and finally has been discharged from service by order 1910 by Commander 4th AI. The learned counsel further argued that Assam Rifle Act has come into force with effect from 2009. As such, those actions taken the delinquent should have been regulated by Assam Rifle Act and not by Assam Rifle Army Act 1950. In support of his submission, the learned counsel placed a notification in Annexure E and further submitted that when a person is dismissed or discharged from service, a proper inquiry should be made. After proper inquiry, action should be taken. After giving an opportunity to the delinquent official to defend himself in support of his submission, he relied on a judgment passed in Palwan Singh versus Union of India, reported in Sergeant Sarge. In reply to the submission advanced by the counsel for the petitioner, Sergeant Sarge, on behalf of the respondent, Assam Rifle submitted that the order of discharge has been passed under Record Branch Instruction Number 1 of 2004 in produced the Assam Rifle Manual Chapter 8, Clause 24, where in the commandant has the power to dismiss any member of the Assam Rifle below the rank of Jemadar. This court has inquired from the respondent counsel whether any medical examination has been conducted in establishing intoxication of the delinquent. There is no affirmation made that the delinquent official was medically examined and found to be intoxicated. Simply, there was no witness. After hearing the submissions advanced by the learned counsel for the parties, and after going through the annexure referred to above, the petitioner's counsel It appears that on 2 occasions, the delinquent official was found intoxicated. On 1 occasion, he was delayed to join his duty, and on 1 occasion, he remained absent from duty without leave. In all those orders have been passed after October 2009, and record also, I do not find any medical evidence available to support or to believe that the delinquent official was intoxicated during his duty. In those annexure also proved that for the offenses alleged, he had already been punished, Malo, the same. And finally, he was discharged from service by order such. Now the question arises. When a person is found to be intoxicated, it is a settled law that it needs to be examined by a medical expert to confirm whether he is really intoxicated. But in the instant case, no action has been taken by the authority. Besides that, it is also clear that the Assam Rifle Act 2006 has come into force from 2009. If it is so, in my considered view, all actions are to be taken against the delinquent official should happen under Assam Rifle Act 2009. Since the instant case in hand, offenses occurred much later after the enforcement of the Assam Rifle Act 2009. The division bench of the High Court was placed to note that the Assam Rifle Manual covers power to the commandant of Assam Rifles to discharge member of the Assam Rifle below the rank of Naib Superior.
Is it 2009 or 2006? Assam Rifles Act?
My lord, this is 2006, which came into force on 20th February 2009.
9.
So till that, it was 1941.
No, in this last line of para 7 of the judgment in reference to Assam Rifles Act 2009.
My lord,
Perhaps it's a typographical error.
it is 2006.
2006 with effect from 2009.
Yes. This may be exercised by a commandant in case a person has got 4 red ink entries, in case it is necessary to send an individual on discharge. Under this provision, a notice will be served on the individual affording an opportunity, which is the regulation, to him to explain his case. Thereafter, the complete case will be forwarded to the sector headquarters along with the notice in reply received from the individual for approval of the sector commander. Thereafter, the documents will be sent to the directory record branch for final settlement of his.
So in your case also, there is no medical evidence?
No. At the same time,
Or no witness also? Is there any witness?
throughout all this proceeding, not even a single witness was produced.
Yes.
Both the learned counsel for bodies are agreed that this procedure has been followed. In as such, there is no controversy about the procedure. However, the question remains that the gravity of offenses involved in the incident case, the same, similar nature of cases, where intoxication in overstay in which the division bench in the erstwhile Gauhati High Court had made an observation, para 15, Palwan Singh versus Union of India. That is, para 15, after tracing out the source of the power of penalty of clause 5 of the ROI, we should now consider the nature and gravity of the 4 violations for which the red ink entries were recorded. To appreciate this aspect, a comparison of the red ink entries recorded against another Assam Rifle personnel, that is, Jus Nathan Joseph, whose case is referred to by the learned government council, may be in order. It is said that in the case of Jus Nathan, where this court altered the punishment of dismissal, my lord, with an order of discharge. So he was dismissed without any benefits. So this High Court changed it to order of discharge. And what happened? Which decision was eventually appealed by the apex court.
That is Balwant Singh. Which was upheld?
That is Jus Netam. Yes. It was a serious offense. So after proceeding, he was dismissed. But
No, which matter was upheld? By the Supreme Court, you said?
the Supreme Court appealed that dismissal.
Okay, upheld the dismissal.
No, which was changed to discharge,
All right.
was appealed.
That is in Balwant Singh.
This is referred in Balwant Singh, the Jus Netam case,
Okay.
where this court altered the punishment of dismissal with an order of discharge.
Hmm.
So it was appealed by the Supreme Court. The violation related to cheating in discipline where the safety of the unit was compromised in Jus Netam case. And insubordination. If we compare this with the 4 violations of the present delinquent, it becomes apparent that 3 charges of the intoxication in 1 overstaying can't be considered in the same class as serious offense, my lord. More particularly when the violation did not jeopardize the security of the unit. Similarly, in the present case in hand, I find that 2 charges against the delinquent official for intoxication and absence from duty without properly obligation. In my considered view, such charges cannot be considered as serious offenses when violation does not treat the security of the unit concerned. Besides that, since for the offenses committed, the delinquent has already been punished, my lord, by way of a rigorous imprisonment. Therefore, discharge from service on the same ground amounts to violation of Article 20 of the Constitution of India. No person shall be prosecuted in punished for the same offense more than once. For these reasons discussed, I feel that such violation of intoxication or absence from duty without leaves, such harsh punishment is not proper. Therefore, I could not agree with the discharge order dated 1910. Accordingly, impugn order dated 1910 is hereby quashed, with direction to the respondent to reinstate the petitioner within 15 days from the date of this order. Then the other one is my lord, number 250-15-55H, Vijay Kumar, my lord. That is,
No, you may refer to the relevant paragraph. Which particular paragraph you're relying on. Here also Balwant Singh is referred to.
yes. Para 9. The same as Article 20.
Yes.
Then and it was set aside. So it is a continuation of this court order following all along.
But in this judgment, there is an attempt to define what is incorrigible offenders, para 7,
Vijay Kumar,
Vijay Kumar.
my yes. My lord, as far as this writ petition 212, my lord. That is my submission.
Okay.
Much obliged.
All right. Yes.
Lordship, uh, in the writ petition, annexure 2,
Annexure 2.
page 21,
Yes.
this judgment and order dated 29/7/2015. Lordship, if my lordship, can I come to page 25?
Page 25.
25,
Yes.
para 10.
Yes.
May I read, Lordship?
Yes.
In that view of the matter, the impugned order dated 15/5/2010 is set aside and quashed, and the respondents are directed to reinstate the petitioner back into service within a period of 3 months from the date of the receipt of a certified copy of this order. Then, Lordship, it is, however, left to the wisdom of the respondent to issue appropriate order if so advised. So liberty was given to the respondent authority to pass any order if so.
No, what was the issue in the writ?
The discharge.
Hmm.
Discharge issued by the commandant that was quashed. However, liberty was given to the respondent to issue appropriate order.
Then?
And Lordship, I'll come to my,
No, by this order, what do you want to, what are you submitting that? Notwithstanding the order dated 29/7,
you know,
but 29/7 order was passed with what directions?
to was any, it was the discharge order was quashed, Lordship, and set aside.
Hmm.
However, the authority were given the liberty to issue appropriate direction if so advised.
Now, pursuant to the this order, what
Yes.
order was passed?
Since the commandant was not the appropriate authority to pass the impugned discharge order, that order was quashed, Lordship, and he was reinstated.
So therefore, this is what the counsel for the petitioner was submitted.
No, thereafter, Lordship, after his reinstatement, Lordship,
Hmm.
Lordship, may I come to my petition at page 5.
Writ petition.
Yes, no, my affidavit.
Okay.
I may be allowed to read Roman 5 and 6. This will clarify all the facts.
Page number.
Page 5, Roman 5 and 6.
You read from the
Yes, please.
beginning. Read from the beginning.
Lordship,
Paragraph 5,
5,
page 5.
page 5, Lordship. Page 5, Roman 5 and 6. This is after reading his statement, Lordship. May I read, Lordship?
Yes.
The petitioner was reinstated in service in compliance with the judgment dated 29/7/2015, passed in writ petition number so-and-so. After reinstatement, he could not be instantly discharged again because his two red ink entries incurred under the Army Act 1950 and enactment of the Assembly Rule 2006 were set aside, and only 3 red ink remained in his service sources. 6. After reinstatement in service, the petitioner knew that if he incurred one more red injury, he will be discharged from service as an incorrigible offender. However, he adds scan regard to the disciplines and committed offense again on 27/4/2017 by absenting himself without leave, remained absent for 4 days, and the act of intoxication on 30 April 2017 while reporting to unit after absence without leave. He was struck summarily by Commandant 42 Assam Rifle on 16/6/2017 under Section 26A and 35 of the Assam Rifle Act 2006. And keeping in view his earlier 3 ink injuries and his request for forgiveness, he was awarded punishment of so. However, the petitioner did not pay any heed to the advice of the unit authority and committed offense again on 6/2/2019 by overstaying leave granted to him, absent of 5 days. He was tried summarily by the Commandant 42 Assam Rifle on 25/9/2019, and keeping in view his request of forgiveness, he was awarded punishment of pay fine for 7 days, lacking entry. However, the petitioner breached the discipline again on 22/2/2019 by absenting himself without leave from 22/2/2019 to 15/3/2019. Absent for 22 days, for which he was awarded 4th red ink entry. The petitioner was identified to be an incorrigible offender, and the details of the offense, this are the facts, Lordship. After his reinstatement, even after his reinstatement, he has absented himself. He was under investigation. So that is why he was starting from page 39. Lordship.
So first, come and explain.
Yes.
It's the Roman 6. So after interference, originally he had 5 red ink entries.
Well,
Then 2 were set aside.
yes,
He was reinstated.
he was reinstated.
After that,
After that, again,
he had another
3 red.
3.
Yes,
So that gave him 6 red entries. Is it?
yes.
3
In total,
in total 6.
yes.
Then what happened?
And Lordship, if my Lordship may come from page 39 of my
39.
affidavit.
Yes.
This is form of hearing of charge under Rule 47 of the Assam Rifle Act. This form is to be filed by the combatant at the time of hearing of a charge against a person subject to the Assam Rifles Act 2006. Then, Lordship, the last column,
Yes.
whether accused cross-examine of the witness or decline or cross-examine. Always state yes or decline before each witness is applicable. So he has declined to be cross-examined. He has admitted to the charges. And thereafter,
This, is there a proceeding book? Like we maintain order sheets, which reflect how a proceeding is conducted. This is a record of proceeding, but it appears
this was the
this is the proceeding.
yes. Then on the next page, Lordship, to be tried summarily. Page 40.
Okay,
Confidential 6, the accused was informed by me that he was at liberty to make any statement and call any witness in defense. But he declined.
then
Then an order was issued to be tried summarily.
so what offenses can be tried by summary proceedings? What are the
Intoxication,
where
like,
do you find it? Under reference to which rule or which provision of the act?
yes, Lordship, under the Assam Rifle Regulation 2016,
1 minute. Where is the proceeding again?
Lordship, under the Assam Rifle Act section,
So you referred to the record of proceeding, where is it? Page number?
Lordship, I have provided one, earlier I have provided one.
No, it's here in your affidavit.
Yes.
Record of proceeding, yes, page number 39. Yes, then
These are the proceedings.
yes,
Yes.
then
Then thereafter, also, batch,
no, you referred to some provision, where is that?
yes, Lordship, the Assam Rifle Act 2006, section 61.
Assam Rifles Act 61.
Yes, Lordship. Punishments otherwise done by Assam Rifle courts. Punishment may be inflicted in respect of offenses committed by persons subject to this act without the intervention of the Assam Rifles Court in the manner stated in section 62, 64, 65, and 66.
No, these are the punishments subject to section 63. But what are the offences which are triable under summary court? That's the question which I asked. When do you have summary court? When do you have general trial, general court proceedings? For what occasions? For what misdemeanors?
Okay.
Your Lordship, what happens in this, all offenses, Your Lordship will go through any of the offenses before section 61 are all offenses. They all can be tried by court martial. But by virtue of section 61, a discretion is given to the authorities. If the CO or the commandant feels that this is a minor offense or he should be dealt summarily, then he can
So-
accordingly
so
within his
therefore,
powers.
in essence, you are saying that the moment you invoke a summary court proceeding, it has to be presumed that this offence is considered to be a minor offence.
Your Lordship, it is essentially that it does not, he deems it not worthy to be tried by a court martial because a court martial is a larger
That's right.
proceeding. Please, Your Lordship.
That's right.
Please.
So it is a minor offence, so it can be decided by the,
Within the powers of the commander.
within the powers of the, but where are the minor offences defined?
Your Lordship, the difference is that even a 1-day OSL or AWL, we cannot classify it as a minor offense because it is a breach of discipline. But by virtue of the discretion vested by the statute, the commandant decides that let's give him one opportunity by giving him a punishment within his own powers. Otherwise, even for a day's OSL or AWL for intoxication, court martial can be convened. But to not, because such offenses keep happening or they're in large numbers, court martial are not convened in each and every case. When they're within the power of the commandant.
What are the offences which are alleged against him? One is intoxication.
Intoxication and absent without leave.
Now you come to section 35 of the Act. The punishment for
Intoxication.
intoxication is defined.
Yes, right. Any person subject to this act who is found in a state of intoxication, whether on duty or not, shall on conviction by the Assam Rifle Court be liable to suffer imprisonment for a term which may extend to 6 months or such less punishment as is in this act mentioned.
Then what was the other allegation? Absent without leave.
Absent without leave.
Section 26.
26. Then,
26 A and B, that 26 plus A and B.
all right, 26A. Then,
Lordship, trial was
hmm,
summary trial was initiated. And-
what are the offences first? First, let us understand what are the allegations against the person. Yes, Mr. Counsel for the petitioner. What are the offences alleged against him?
My lord,
If my lordship, can
my-
you see my paragraph 41, page 41, it's there,
Page 41
page 41. Page 41, 42, 43
of the affidavit.
of the affidavit, lordship.
Intoxication, absence
Yes.
of leave,
Yes, lordship.
and
And next page also,
overstay. Overstay.
overstay. Then next page, absenting himself without leave.
That is there in page 41 also.
These are different dates, lordship, different occasion.
So these are essentially there are three allegations.
Yes,
Intoxications,
Absenting without leave,
and
yes.
overstay.
overstay.
So is overstay also defined somewhere? It must be defined somewhere.
Overstay.
26,
26B.
26B.
All right.
B, without sufficient cause, overstay leave granted to him.
Okay. So essentially, what your case, case projected by the Assam Rifles is that he already had red marks.
Yes,
Then because of these allegations, further red marks accumulated.
My lord,
Therefore, he was considered to be a person unsuitable.
unsuitable.
And therefore, as per the proceedings under 107 and 108 regulations, he was discharged. And prior to discharge, the procedure prescribed for giving him notice, etc., was followed.
It was for the lordship.
He replied to it and he
Replied,
was
yes.
discharged. What is the effect of discharge? Does he get his pension or not?
Pension, Your Lordship, if he
No.
has the requisite qualifying service, which in case of a rifleman would be 20 years, then he would get it.
Okay, what is his qualifying
19.
service?
He has served only 19 years,
19 years.
19 years, 2 months and 17 days.
What are the punishments? Where is discharge prescribed
Lordship.
as a punishment?
Lordship, it's in the Assam rifle regulation.
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 Which regulation number?
Assam rifle, 108.
108. No, this is the grounds which will relate to discharge.
Yes.
I am asking you, is discharge defined? Or specifically mentioned somewhere?
It's in Rule 25, Your Lordship.
25, Rule 25. Yes. This is termination.
Yes, Your Lordship, the termination is done by virtue of either compulsory retirement or discharge. This is read with Rule 17 and Section 11. Your Lordship.
There is no dismissal. Must be dismissal also.
Dismissal, Your Lordship, comes under Rule 20, read with 17. If it is done in under provision of Rule 20, then dismissal or removal can also be ordered.
Under the record office instruction number 10 of 2000. The rule was amended as under. Please amend to read discharged. In place of dismiss or removal of this personnel who has got 4 red ink entries.
This is amendment of which rule?
This is the office record office instruction number 10 of 2000.
This is to include discharge. Show us the rule, show us the amendment.
Do where's the amendment?
Discharge is defined under section 21. Discharge is there under section 21. Sorry, under rule 21. Yeah.
Yes, Lordship, the record branch instruction number 1 of 2004
Do
of
you
the
have a-
Assam Record
Do you have a
President.
copy?
I don't have a copy, Lordship.
Furnish a copy.
May I read, Lord? I have
No,
only
you-
one
you-
copy that
you
is.
give us a copy, we don't know what copy you'll be reading from. You should furnish a copy to the other side council also. What, Assam Rifles, you don't have copies to furnish? You should have all these copies ready, you should serve it to the other side council also. Ordinarily, that's the purpose of filing pleadings, so that whatever documents you have, you bring it on record. You are using what resources to supply these documents? Yes, you have a copy?
Yes, Lordship. This is the
Discharge.
record branch instruction number 1 of 2004 for Assam Rifle President. And then 5
Yes,
is discharge disposal of undesirable inefficient personnel. Right, chapter 8, rule 24 of the Assam Rifle Manual confers power on the commandant of Assam Rifle Battalion to discharge any members of the Assam Rifle below the rank of Naib Superior. This power may be exercised by a commandant in case where a person has got 4 or more red ink entries. In case it is necessary to send an individual on discharge, under this provision, our notice will be served on the individual, affording an opportunity to him to explain the case. Thereafter, the complete case will be forwarded to Sector HQ along with the notice and reply received from the individual for the approval of the Sector Commandant. Thereafter, the document will be sent to the Directorate Record Branch, UPAO, for final settlement of the individual.
now let us come to the discharge order itself. Now, this discharge order precedes a show cause notice, isn't it?
Yes, Lord.
This show cause notice was on 2020, February 2020. This is page number 40 of the writ petition. Now, how do we explain the invocation of the relevant sections of the Army Act for
Lord,
personnel who belongs to the Assam Rifles?
Lord.
When there is already an Assam Rifles Act, well defined what offences, etc., are there.
Lord, the other charges. Mhm.
You get these queries, we'll continue. When do you want it? Tomorrow?
Tomorrow,
No,
DB.
tomorrow is a DB.
Day after?
Okay, okay.
Day after. Tomorrow DB means there's no single after DB.
Normally, no.
It can be held if you desire, my lord.
We can continue tomorrow
Malo?
After DB.
after DB. Or you want it on Thursday. If you need time to gather your instructions,
Okay, and Thursday on,
Thursday,
my lord.
all right. Then Thursday, we'll take it up.
No,
We'll give priority over the other hearings.
my lord.
All right, this is a partnered matter, so we'll take it up first
My
on
lord.
Thursday. All right. And once he completes, if you have any rejoinders to issue, then you can do that after he completes
Malo.
on Thursday.
I have already filed a reply also. On the question
No,
of.
no, no, rejoinder in terms of your arguments, if you
Mano.
have any. Can I get a stapler? No, you staple it here. Then you connect it to this document. Put it along the order sheet. Right? Yeah. Make a hole on the top. Okay. Heard, and then the counsel for the petitioner. Also heard counsel for the respondents, Union of India. Stop. Counsel for the petitioner has concluded his arguments with reserving his right for a rejoinder if required. Stop. Submission of the standing council, CGC, council, central government council remains inconclusive. Matter to be listed for further hearing on Thursday. Thursday will be 7th.
As part of.
As part. All right.
जमीन लेके जाते ये डेली चाहिए था 계속 나와 이 와서 되나 다니는데 저는 뭐 언니 맡은 게 힘이 전에 시원한 나와 되게 멋지지 사람들과 모델 맡고 हेलो ओए ओए एक बार कोर्ट रूम दे मतलब कैमरा ने जस्ट रिव्यू गर्यो जज को ना कैमरा ने एक बार एडजस्ट कुने त मिन आइदिना साइदिना one day